Chad DeSoto is making a final attempt at overturning his conviction. His case was up for appeal in the Supreme Court today, where attorneys argued over what's called burden shifting and the high emotions that went into the high-profile trial. Here's more.
Mr. DeSoto was a deeply troubled young man.
Defense attorney Stephen Hattori says there is no disputing that Chad DeSoto was indeed the man who drove his car through a crowded two-mile sidewalk, killing one, then jumping out of his car and stabbing two others to death, and in the process injuring 11 others in February of 2013. The case was solely about whether or not DeSoto knew what he was doing at the time. Now, in his appeal, Attorney Hattori says that apparently, during DeSoto's trial last year, the trial court did not properly instruct the jury on diminished capacity, which differs from the defense of not guilty by reason of insanity. A finding of not guilty by reason of insanity would mean that the defendant is not guilty and would then be sent to a mental institution, whereas diminished capacity would mean the defendant would be guilty of a lesser offense. Apparently, the jury never knew they had that option.
If it's an affirmative defense, then you don't have to specify negated as an element. However, because it goes towards a mental state, it's not an affirmative defense. And so we believe that, like self-defense, there should be an instruction in the elements that the government must disprove self-defense.
Furthermore, Hattori believes that certain comments made by lead prosecutor Phil Tydenko negatively influenced the outcome of the trial.
When the prosecutor was warning the jurors not to, don't let him walk out of here on temporary insanity defense, that he doesn't have mental responsibility when the evidence shows he does, because he hasn't proven it. And so that's also inflammatory, because it warns jurors that if you return a verdict not guilty, he's going to go free, which is not the case with an NGI verdict. This is one of the most powerful prosecutors on the island, actually the most powerful prosecutor on the island, standing in front of 12 jurors, basically telling them, you know, if you say not guilty, this guy's going to walk. He's going to be out there at Kmart, at the mall. He'll be out there. But it also concerns me because he also shifts the burden of proof. He tells the jury that he doesn't have mental responsibility, but when the evidence shows he does, okay, the government bears the burden of proving mental state beyond a reasonable doubt. That, in particular, is burden shifting that is not permitted.
To say that the prosecutor is out of bounds by focusing on the burden as far as the affirmative defense of insanity is just to ignore that that's the crucial issue in the case. And you can say that it's burden shifting, but when the defense does have the burden, it's not burden shifting. It's commentary on the defense's failure to carry that burden.
The Supreme Court Justices Robert Torres, Philip Carbolito, and Catherine Merriman took the case under advisement.